Hi viewers, I am Jhansi Gloria. I am working as an assistant professor, Department of Business Administration in St. Joseph's College of Arts and Science, Autonomous, Cuddalore. Today we are going to discuss about the topic of contract of indemnity and guarantee. This topic covered in the subject of legal aspects of business, Unit 5. First, we are going to discuss about the contract of indemnity. What is meant by contract of indemnity? According to section 124 of the Indian Contract Act 1872, a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called a contract of indemnity. For example, in a contract of indemnity, Mr. A promises to pay Mr. B. If any loss happens by the conduct of Mr. A or any other third party, then all the loss will be compensated by Mr. A. This is a contract of indemnity. And another one example, B contract to indemnify C against the consequence of any proceedings which C may take against C in respect of a certain sum of rupees 2500. This is a contract of indemnity. Next, definition of contract of indemnity. According to Halsbury, he is a British lawyer. He defines the contract of indemnity, and indemnity is a contract express or implied to keep a person who entered into a contract or incur any other liability indemnified against loss independently of the question whether a third person makes a default. That is called contract of indemnity. Next, essential elements of contract of indemnity. The above definition provides the following essential elements. Number one, there must be a loss. The claim for indemnity does not hold if there is no loss suffered. And number two, the loss must be caused either by the promiser or by any other person. And number three, indemnifier is only liable for the loss. Here, it is clear that this contract is contingent in nature, which means where the promiser performs his obligation only when certain conditions are met, and it is only enforceable where there is any loss occurred. Next one, types of contract of indemnity. If there are two types of contract of indemnity, and number one, express contract, and number two, implied contract. First one, express contract. An express contract is a contract whose terms the parties have explicit set out. This contract is made either written or oral. Number two, implied contract. An implied contract is created when two or more parties have no written contract, but the law creates an obligation in the interest of fairness based on the parties' conduct or circumstances. These are the types of contract of indemnity. And next one, we are going to discuss about the contract of guarantee. First, the definition of contract of guarantee. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person whom the guarantee is given is called the creditor. The guarantee may be either oral or written. Then the contract of guarantee will be mentioned in the section 126 of the Indian Contract Act 1872, also with three other terms, namely number one surety, and number two principal debtor, and number three creditor. The person who gives the guarantee is called the surety. The person for whom the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. For example, Mr. A takes a loan from the bank for which Mr. B has given the guarantee, and that if A default in the payment of the said amount, he will discharge the liability. Here, B plays the role of surety. A is the principal debtor and bank is the creditor. This is called the contract of guarantee. Next one, essential elements of contract of guarantee. If there are 8 essential elements of contract of guarantee, and number one, the concurrence of the all the parties, and number two, liability, number three, existence of a debt, number four, consideration, number five, a writing not necessary, and number six, essential of a valid contract, number seven, no concealment of fact, and number eight, no misrepresentation. These are the essential elements of a contract of guarantee. Next one, kinds of guarantee. A guarantee may be given in two ways. Number one, specific guarantee. Number two, continuing guarantee. And first one, specific guarantee. A guarantee given for only one specific transaction between the debtor and the creditor is called a specific guarantee. It is intended to come to an end with the completion of the transaction. And number two, continuing guarantee. Continuing guarantee means a guarantee extend to a series of transactions. The guarantee is not limited to only one transaction, but too many transactions. That is called continuing guarantee. And now I conclude my lecture. I am expecting more satisfied to you, and thank you for all.